May it please the court, Your Honor, I'm Joe Wyatt for the appellants, Snyder and Tactical Edge LLC out of Clarksville. I would like to reserve 4 minutes for a
4 minutes, yes, Mr. Wyatt.
Nice to see you all.
Good to have you with us.
Thank you. Your Honors, my clients were found guilty of fraud, conversion, unjust enrichment, but the main cause of action in this case has been fraud from the beginning. The trial court found fraud, and the plaintiffs have cried fraud all along. I was not the first attorney on this case. Nevertheless, this cannot be fraud for one key reason, and that is the facts that govern this case are not reasonable. The alleged fraudulent misrepresentation or statement that was allegedly made by Mr. Snyder was a promise of an LLC membership interest to the appellee, Mr. Numbers. Whatever the plaintiffs say Mr. Snyder told them or promised them or represented to them, based on the circumstances here, they were not justified in relying wholeheartedly on those words. Now, this case centers around...
So your theory is even if he did lie to them, it was so ridiculous a lie that they shouldn't have believed it, and they're just responsible for their own folly.
Well, that's what the case law says, all the case law. But I don't believe my client lied. This case centers around money paid to the LLC in the amount of some $721,000 over the course of about 6 months and in several infusions of cash. There is no writing, no contract, no receipt, not even a scribbled, memorandum on a napkin that would reflect the terms of the parties' agreement. And that's very unfortunate for both sides. Only the bare assertions of these appellees as to the reasons and nature of the transaction exist. And I just want to go over those just quickly, those 7 infusions of cash. On June 12th, 2015, Mr. Numbers paid $93,000 to the LLC. August 31st, he paid $25,000. September 15th of 2015, $14,000. A week later, on September 22nd, $50,000. October 6th, $160,000. October 14th, $14,000. October 26th, $65,000. Now, throughout this time, Mr. Numbers claims that he was asking and checking up on the changed operating agreement that would assign him his 30% of LLC membership interest in this Tactical Edge. It's a LLC, it's a business up in Clarksville that sells guns. But both of these gentlemen are former service members. We thank them for their service. Up in Clarksville, we have a lot of single-member LLCs. After a man gets out of the service, they are still young, they want to do something else. And that's what happened here with these two. But even after Mr. Numbers claims that Mr. Snyder put him off and put him off, he kept giving all this money. And we're not talking about $500 or $1,000, even $5,000, as would be the case in a regular loan scheme, loan situation. We're talking about a number that reflects most people's life savings. And then Mr. Numbers brings his mother in and encourages her to give Mr. Snyder, even though it's been 6 months, he has nothing to show for his money, on paper anyway. He gets his mom to give $300,000 more to the LLC. Now, this is a lady that has a Swiss bank account.
Doesn't the fact that there were 7 different, regarding Mr. Numbers, 7 different transactions, each for different amounts of money, some as close as 1 week apart, doesn't that support the plaintiff's claims that these funds were provided for specific purposes? which supports the claim of fraud because your client was unable to come forth with any evidence that these funds were used for those purposes.
Well, I would argue with you that there's no proof that the purposes for which the money was given were not realized. There's plenty of evidence in the record, Your Honor.
Well, isn't there testimony by the plaintiffs that the money was given for this purpose, such as an oven? One was for an oven. Another one was for buying inventory. Another one was for a second store or a second business. There's nothing your client came up with to show that any of those tangibles existed or resulted from the loans.
Well, as I say, I would argue with that, but it does show that the parties were talking. There was testimony.
How would you argue with that?
Well, Mr. Snyder had an answer for all of that. He was talking with Mr. Numbers. You never denied that, and he put the money for which the money was given, the use for which the money was given. He put the money to those uses. It never went into Mr. Snyder's personal bank account. I mean, we have a stellar accountant. He was their witness. We have a stellar accountant who used to work for the FBI, for the Financial Crimes Division, that said these books were fine. He didn't see any fraudulent.
And so was this the same accountant that prepared the tax return for the LLC?
Yes.
Okay, and so that stellar accountant also showed these payments as loans?
Yes.
Okay.
When I first came on the case, I thought this was an investment. A prior attorney had called it a gift, which I don't agree with. And the court finally denominated it as a loan. I don't, the fact that the court found it to be a loan, I think negates fraud because there's no scheme. A loan is voluntary.
So what is your position? What was the nature of the investment then? Was it an investment in the LLC itself, or was it something else?
It was the LLC, things that the LLC wanted to do at Mr. Numbers' behest. It was Mr. Numbers that approached Mr. Snyder and wanted to be involved in this. He even worked there as an employee for a while. He knew the business in and out. He was with Mr. Snyder daily. Even if he wasn't working there, he would come by. I mean, this is all on the record, but no one on God's green earth would have conducted themselves as the appellees did here. That is because, the facts of this case defy all common sense on both sides. There was no writing that would justify the giving of this money. There was no, even though the trial court says this was a loan, the trial court didn't give us the terms of what she said the loan embodied. She just says, hey, the money's all due back to Mr. Snyder now, and you're in default. Oh, but you frauded him. I don't see how those can coexist, a loan and fraud. Tennessee case law on fraud is replete with the phrase, justifiable reliance is not blind faith. Just about every case that you all have handed down says that, even the Supreme Court cases. Neither of these, the appellees insisted on a contract or a written memorandum that would have memorialized and reflected the terms of the payment of these large sums of money, what they were to get for the money, how it was to be repaid, what was going to be realized for it. We have Mrs. Wilder Roberts, Mr. Numbers' mother, has a Swiss bank account. She had a financial advisor that she said she consulted on the issue of whether she would give her $300,000, and she chose to actually give the $300,000. And she described the scenario where she met with Mr. Snyder. Now, it was all he said, she said, literally, in that courtroom for 3 days. how do you disprove bare assertions? You really can't if nothing's written down.
Well, the trial court made credibility findings, and
The trial court said that she would not believe anything my client said, and so, yes, she found it.
that's pretty compelling.
She made a credibility finding, there's no question.
And you've got to show, I think it's compelling or clear and convincing evidence that the trial court's conclusion of credibility was unfounded. And
No,
I haven't seen that yet.
Well, the case law says the trial court's in the best position, and it's sort of hard to overturn that. But that was her finding. But how can it be a loan and fraud?
Your time is almost up. I'm really interested in hearing about the corporate veil issue.
Well, that accountant told the court that none of this money ever went into the personal account of Mr. Snyder. The one thing that they did cite was a $600 ATM withdrawal out in Las Vegas during a trade show.
And what standards were used to determine the piercing of the corporate veil? Was it, well, what case law, what standards were used by the court?
Well, yeah, as I recall, it was just fraud.
It was the Allen factors, wasn't it?
Yes, of course.
Well, let me ask you this then. After your case was tried and decided, but before your briefing, the state Supreme Court came out with a case called Urey versus Recovery House of East Tennessee that said the Allen factors were not the factors to use in determining the piercing of the corporate veil, and rather the standards in Continental Bankers were to be used. And that wasn't really briefed by either party, and the briefs were due. The briefs were filed in August and September, and Urey came out in January. So I'm wondering what do we do with that?
Well, we could rebrief it if you like and come back and argue again. But
Well, my inclination is to ask you to rebrief it, and
I'm a little embarrassed that I didn't, see that. But
well, I understand. It happens. But I'm also concerned about whether we should remand it to the trial court for another hearing based on the correct factors.
I actually thought of that, Your Honor. I was afraid to ask, but I
Well,
actually thought.
After I hear from
For other reasons.
opposing counsel, I may ask the panel to request further briefing on those 2 points.
Well, I don't think I'll need much rebuttal then, but I did want to just say, none of this was sensible, and the payment of these substantial sums of seven successive occasions clearly and smartly fails to satisfy the element of fraud, which requires that a plaintiff reasonably relied on the misrepresentations, if there were any, that a person made. And if there is no fraud, that would necessarily negate the other causes of action and also punitive damages as well. The question, Your Honors, is when does it become a person's own fault for something they did? When is it no longer someone else's fault? And the finger points at Mr. Snyder 100% in this case so far. Thank you.
All right, thank you, Mr. Wyatt. We'll hear from you on rebuttal. Good morning.
Morning, Your Honors. May it please the court, I'm Kristen Mosier, and I'm here for the appellees Darrin Numbers and his mother, Jude Wild Roberts. We're here today because we are respectfully requesting affirmance of the trial court's judgment. This case is really a very heartbreaking tale of betrayal. A retired veteran, Mr. Numbers, was reeling after a divorce from a long-term marriage. He trusted his fellow veteran, Mr. Robert Snyder. He called him brother. only to lose $421,900 in loans. He ended up homeless in his car after loaning all this money to the business that he was told he would be part of. Mr. Snyder's then preyed on Mr. Number's mother, Ms. Wilder Roberts, siphoning her $300,000 in savings, promising her a family legacy, leaving her in a very bad financial shape. She couldn't repair her home. This is a case that shows that a leopard never changes his spots. The record is replete with Snyder's deceitful actions, extending all the way to the IRS, the courts, another aggrieved party, Daniel Defense. A verdict was put down from the court in Georgia for $1 million. A fact scenario almost spot on to the fact scenario we're here for today, and even stiffed his own lawyers, several lawyers that were helping him throughout his business. So we're going to ask you today to find that the trial court rightly held that Mr. Snyder and the Tactical Edge are liable for fraud, conversion, unjust enrichment, the veil piercing, we'll get to that, understand that's a concern, and $300,000 in punitive damages. These findings are unassailable under Tennessee Rule of Appellate Procedure 13D because the appellants failed to show by a preponderance of the evidence against the facts or clear and convincing evidence against Mr. Snyder's non-credibility. So there is a lot going on here. First thing to keep in mind is this case has been pending. This money was loaned in 2015. So Mr. Snyder and his business have had $721,000 for the past 10 years of my client's money. First, let's talk about credibility because this is a he said, she said case. It is strange that there were no writings, except both my clients testified that Mr. Snyder told them over and over he was going to get his attorney to draw up the papers. The trial court's credibility call on Mr. Snyder is dispositive. She found that he lacked any credibility. The trial court, I think, knew this case would end up on appeal, and so she wanted to send Your Honors a message. She said she wouldn't believe him if he testified it was hot outside on a 100-degree day. She said the court will take judicial notice that it was in the triple digits while we were trying this case, and she wouldn't have believed him if he said it was hot outside. This is how bad his credibility was under oath, and she wants y'all to know that. I think that was her way of telling y'all that don't believe anything he says, believe the plaintiffs. So one of the main questions here is, what was the nature of the money that was paid into the Tactical Edge? Well, my clients both said it was loan money. Ms. Wilder Roberts testified that it was a loan and she was supposed to get a 10% return on her loan, and that is what the trial court did find and award. So either between prejudgment interest or the 10% she was supposed to get on her loan, she is supposed to get returned back her $300,000 with 10%. That was a finding of fact. She found that Mr. Numbers should be returned all of his money plus prejudgment interest. Mr. Snyder did make a few payments. He began some repayments on the money that Mr. Numbers put into Tactical Edge. He paid him a lump sum of $25,000 and made then a couple $5,000 a month payments on the checks that he wrote, repaying. It says loan repayment on the checks. Then he stopped paying Mr. Numbers, and so this lawsuit got filed. And in his answer to the lawsuit, he said, this wasn't a loan, this was a gift. This was neither a gift nor this was a gift. So, was he lying to the court when he filed his answer? Was it a fraud on the court? Why would my clients put that much money into the Tactical Edge? That's a great question. Well, you have to believe what my clients say, and it's pretty believable. My client said he was promised a 30% share in this business, and so he felt like he was investing into something he was going to be a part of. But there was no way he could have ever gotten 30% because Mr. Snyder had a business partner named Joey Griner. Mr. Griner was deployed at the time, so he wasn't around the shop. My client didn't even know that guy existed. And Mr. Snyder never said, well, I actually have a partner. When he came back from his deployment, he said, what the heck's going on? Who's this guy? He wants to give us money? And Mr. Snyder says, yeah, he's just giving us money. And the partner says, this doesn't make any sense. Nobody gives money for no reason. It's because he doesn't know that his partner's trying to promise another guy to share the business. So he says, don't take it. Well, Mr. Snyder takes it anyway. That's in violation of the operating agreement. Both partners have to assent to money, loans, coming into the LLC. So all this money is coming in ultra vires. It's against the operating agreement. But Mr. Snyder never told Mr. Numbers that. Number two, if this money is a loan, why hasn't Mr. Snyder repaid it? He doesn't say, I couldn't afford it. He just doesn't repay it. Why is that? He doesn't say, yeah, it was a loan, but he just literally gives no excuse. We've been litigating this case for 10 years. It's because this entire time he's been saying, I don't have to pay it back. It's a gift. It wasn't until counsel joined the case 1 month prior to trial. He did a great job. The former lawyer that had been litigating the case for 8 years withdrew 1 month before trial. Terrible. He did the best he could, but he comes in and said, well, no, this money's an investment. No one had ever said it was an investment. So as you can see the whole time, Mr. Snyder, this is just like a moving target as to what this money is. So that's how you know that Mr. Snyder is not telling the truth about anything he says. My clients made many statements in court that the trial court relied on for why this was actually fraud. Her memorandum and final order is 25 pages, and it's replete with her findings of fact as to why this was fraud. And all the court has to do is pull from her findings of fact and uphold them, because the appellant has shown no reason to preponderate against her findings of fact. So then we move on to, was it reasonable for Mr. Numbers to rely on the oral promises, given that there's no writings? Well, absolutely. Mr. Snyder exploited the brother bond that Mr. Numbers testified to. He said, I believed it truly in my heart, and the trial court found it reasonable. There's been nothing shown by the other side other than trying to re-argue the case, which doesn't really work on appeal unless he has some kind of proof that the trial court made erroneous findings of fact, and nothing has been shown in this courtroom today to show that. So we have other things that went on. For example, there was a conversion of the money. If it wasn't a loan, what was it? Maybe it was just a conversion of this money. One thing that happened was when Ms. Wilder Roberts paid $300,000 to buy the Eagle Creek Armory, some of her money went to buy a piece of land in Kentucky. It was eventually sold for a profit, $9,600 profit. It happened during 2020. The sale of the land never shows on the company books. In fact, the accountant told us in court that the land was still showing in 2021 and 2022 on the tax returns. It's still there. He has no idea his own client has sold this land and made a profit. What happened to that money? What happened to the proceeds from the sale of the land? What happened to the profit? It's gone. It's not on the books. There's all these hallmarks throughout this case that show that this case is replete with fraud. What about veil piercing? Well, unfortunately, I didn't know about that case either, so I'm sorry to say that. But I don't think we need to rebrief this case respectfully, Your Honor. There were so many factors that show that Mr. Snyder should be held personally liable for taking this money. He's not being sued just because he's part of the LLC, president of the LLC, chief member of the LLC, what have you. He was directly involved. He was the one orchestrating all the fraud, making all the statements, taking the money, and putting it into his business. And then, when he takes it in, he marks it as a loan on his tax returns, not just any loan, but a recourse loan. Now, I didn't know what that was until I got on this case. A recourse loan is where a member of the LLC will guarantee the loan if the company doesn't have enough funds to repay the loan. And what the member gets in exchange for this is that counts towards his basis that he's put into the LLC. And so he gets tax benefits from claiming it as a recourse loan. So he's already told the IRS that he will personally guarantee this money. So we're kind of talking about a distinction without a difference. He's already told the IRS he's personally liable for these funds. And so it's not much different, no matter what the reasoning was that this court found, that he is personally liable. So also, an LLC is not a shield from which you can hide behind to prevent yourself from being held personally liable for fraud. Mr. Snyder's own actions, his own words, were fraudulent. He committed the torts. And so he cannot hide behind the fact that the money went to the LLC. His own tortious actions hold him personally liable for his actions. He's also unjustly enriched, as we discussed. He's had this money for 10 years. He marked this money as loans on his tax returns and got tax benefits from it. So he's also been unjustly enriched from the use of my client's money. Now, as far as punitive damages, there really wasn't much argument on the side of the appellants against punitive damages. And so the court found very specifically, and she walked through the factors from the Hodges versus Tooth case for finding punitive damages. And in a case like this, where there was intentional misrepresentation, and she found harm from this, she found reprehensible behavior, she found that Mr. Snyder had a pattern of telling people he would pay them back, such as his CPA, his attorneys, Daniel defense, as well as the plaintiffs in this case. She says, we're going to have to deter this conduct. He hasn't learned. He was hit with punitive damages in the Daniel defense case out of Georgia. That was he took $300,000 of their money, was hit with $1 million. She says, he hasn't learned his lesson. We have to teach him a lesson. We have to send a message that this conduct is not okay. And so we had a separate hearing. We had to go back and have that redone, but we had a separate hearing. She heard all the proof, and she was especially distressed during the punitive damages phase of the trial because she couldn't make heads or tails out of what his financial condition was. He didn't bring canceled checks. He couldn't answer questions on the stand. But what she could do was look at the compensatory damages that had been awarded and then award punitive damages accordingly. And that is what she did. And the appellants have shown no reason to overturn her findings, Your Honor. So we would respectfully request that you uphold the findings of the trial court and affirm her judgment. Thank you.
Do you want to ask about the?
Well, she addressed the, so you don't think we need to rebrief it under URI standards?
I don't think so. I think there's other reasons why holding Mr. Snyder personally liable can be upheld in this case.
Well, okay, I'll consider that.
Okay.
Thanks.
But would you request a brief? We'd be happy to do it.
Well, I have to consult with my cohorts, and if one comes out, we'll put down an order.
Thank you.
All right. Thank you. Rebuttal? Rebuttal, yes, sir? You
Your
want-
Honor, may it please the court, I had to sit through 3 days of just hearing Miss Mosher hammer my client, I tell you. But I do feel that a few of the things she said were a little bit off. To my knowledge, the land sale is on the books. This entire talk about
You say
non-recourse.
to your knowledge, we're limited to the record.
Well, it's in the record.
You telling me the accountant says
Yeah.
that the land is still on the books?
Yes, and
Right,
Mr.
but the problem is it's been sold.
It's been sold, the money was put back in the LLC.
That's not what the accountant said.
Well,
Well, we'll look at the record.
Yeah,
okay?
thank you very much.
Okay.
But this entire discussion about non-recourse loans, my client, which is also in the record, doesn't have anything. He lives in his ex-wife's house. All that's in the record, and we did bring bank statements to show that. I was focused more on the fraud. I would like a chance to rebrief the case, because I want to clarify some of those things that were just said, but also some other things that were in the brief of the appellees. Judge, the fact that 3 lawyers disagreed with the nature, the character of this money, as well as the litigants themselves, I believe, makes a case that the appellee's reliance on whatever Snyder said just wasn't reasonable. Maybe the first time, the first $91,000, maybe it was reasonable then to trust the guy. But not 6 more times and then bring your mom into the situation and get her to put in $300,000.
But they were each for a different purpose.
Well, that's what they are saying. And we agree, my clients agree to an extent. But then they just took the narrative and ran with it. And we can't prove anything without a single piece of paper that would justify or explain what the money was for each and every time.
And since the trial court found your client to be wholly incredible, those pieces of papers would have benefited your client if they were to say what your client claims they would say.
Yes, Your Honor, the trial judge never said why she felt that way, and I don't know why she said that.
Well,
My client felt to be
It's
very...
pretty obvious to me from what I've read so far, but I'll look further.
The way it was written, it makes my client sound very bad. But these are just not good business people, none of them, both sides. I don't understand how anybody could do what they did. What we do have in writing are checks, Your Honor, just a minute. Checks that were always written to the LLC or transfers, wire transfers going to the LLC account. It never went into Mr. Snyder's personal account. You know, Ms. Mosher said that Mr. Numbers didn't know about Mr. Griner, this deployed member of the LLC. Yet and this is in the record, Mr. Numbers met the guy and worked on the premises. He knew the guy's wife who was working there. He knew about that member. Your Honor, there's just a lot here, and you know, we were all confused on it. We were all taken aback by it. We would ask for a little bit more of an opportunity to clarify and you know, even rebrief the case. Thank you.
All right. Thank you both for your arguments. We'll take your case under advisement. That concludes the morning docket.